Welcome to Benefits Redefined, a series of conversations focused on rewriting the employer playbook. If you're an employer today, you're being pulled in a dozen directions at once. Rising healthcare costs, increasingly complex care decisions, growing employee expectations, and constant innovation. Too often, those forces are treated separately. Costs live in one conversation, care in another, culture somewhere else entirely. This podcast exists because those things don't actually operate in silos. I'm Richard Silberstein, and I work with a group of colleagues across the country who spend our time helping employers move beyond transactional benefits and towards strategies that actually work in the real world. Each episode features practitioners who are in the work every day, not theorists, not sales pitches, but people helping employers navigate what's next in employee benefits, healthcare risk, and enterprise strategy. Today's Benefits Redefined episode is the new fiduciary era, broker lawsuits, PBM transparency, and what employers must do now. Over the past year, we've seen lawsuits involving some of the largest benefit consulting firms in the country, increased scrutiny of broker compensation, and new legislation aimed at pharmacy transparency. For many employers, this raises an important question. Are we fully meeting our fiduciary responsibilities when it comes to managing healthcare benefits? Today, we're joined by Stacy Barrow, one of the country's leading employee benefits attorneys, to help us unpack those developments and what they mean for employers. Great to have you here, Stacy.
Great to see you, Richard. Thanks for inviting me.
So, for those that don't know Stacy Barrow, I'll give you a little bit of a brief update. But Stacy, let people know a little bit about you, and then I'll give you my unedited ChatGPT version.
Sure. I'm an ERISA attorney with 20 years of experience in private practice. I'm based in Boston, Massachusetts at my firm Barrow Lent, and I specialize in health and welfare and employee benefit plans.
Yep. And I've known Stacy, we were just talking about it, for about 20 years, and he is a dear colleague of mine that whenever we have a client that has a situation and we need the bat phone to figure out if something is legit, not legit, client has a tough question around employee benefits, Stacy's our go-to person. So we really appreciate those 20 years of working with you, Stacy.
Thank you.
So Stacy, let's kick off in terms of what's actually happening with some of the lawsuits. Many employers are hearing about the lawsuits involving large brokerage firms like Marsh, Gallagher, and Lockton. At a high level, what are these cases about and why are they getting so much attention?
Yeah, so at the end of 2025, there were 4 class action lawsuits that were filed challenging how employers are administering their voluntary benefit plans. And by those, I'm referring to the voluntary accident or critical illness or hospital indemnity plans, often referred to as the worksite benefit programs. And the claims here are that the brokers and the employers breached their fiduciary duties with respect to those voluntary benefit plans, largely by failing to adequately monitor the premiums and commissions. So, we know employers are fiduciaries when administering their plans, but the claim here is that the brokers and consultants are also fiduciaries because of the discretion that they exercised over these plans. The brokers essentially are accused of curating the list of carriers that they present to their clients, and they removed the options that the broker deemed to provide insufficient commissions. Another allegation in the lawsuit is that the brokers essentially stripped the commissions out of the employer-paid services and then put them into the employee-paid voluntary benefits. So in other words, they removed the commissions from medical, dental, vision and allegedly loaded them into the voluntary plans. And so then that kind of translates back to the employers that they're accused of receiving improper benefits in connection with the alleged excessive commissions that were charged to the plan participants.
Yeah. And so for employers sponsoring health plans, should they view these lawsuits as something that only impact brokers, or could plan sponsors themselves face scrutiny if they're not actively overseeing vendor relationships?
Oh, no, I think it definitely involves both. It's not just about the commissions and the transparency. The transparency is really the tool that the plaintiffs are using to go after the brokers to help make the case that there are fiduciary violations out there. So, the plaintiffs are challenging the fiduciary status of the brokers and how the employers governed their plans under ERISA. So, while these transparency rules may give us the data that the plaintiffs needed to file the suits, the real argument here is whether the brokers acted as fiduciaries, whether they exercised enough discretion to be considered fiduciaries. If they're screening the carrier bids and they're only presenting options that pay high commissions, it's arguably exercising discretion. If they're controlling how the money flows, into products that generate the best commissions, then arguably they're acting as fiduciaries and exercising discretion over the plan. The cases are in their infancy. The complaints have just been filed. We haven't seen any responses from the defendants yet. And there may very well be some good answers to some of these allegations. But if they're to be believed, there may be some issues with how these plans are put into place.
Yeah. And I think we've seen this before, Stacy, where, there is a lot of our peers that are, benefit brokers, consultants, which you represent a lot of our peers that we know from, as we talked about, some of our associations in the past. And there are a lot of people that are doing things the right way, that are, vetting the carriers, that are disclosing the compensation, and that are not, having an egregious amount of compensation built in for themselves. So we just want to acknowledge that there are a lot of good actors and professional peers. But what's surprising, and we've seen this before in the past, where there are some named, prominent, large benefit consulting firms where, based on what we've heard and seen, where there are, I'd say, some egregious amounts of compensation or overcompensation, right? And I think the feeling is that the employer should have known that, or somebody at the employer should be sort of watching that hen house, not just leaving it up to the consultants. Is that sort of the gist of that you've seen, or from what you've heard?
Yeah. It's certainly possible the employers were aware of it, right? They might have been happy to see that savings. If the broker says, hey, we can make what we need to make through the voluntary products, we don't need to make as much on the other products, I could see where that might look appealing to the employer.
Yep. And in the podcast landing page show notes, we're going to have sort of a fiduciary checklist. But I think what Stacy has seen and what he would advise clients that are calling up is there's probably processes and steps that HR need to think differently about going forward, so they can basically say, hey, we followed these things, we did these things, so if we ever get called to the carpet, we can say that we acted in the best interests of the employees as a fiduciary. And we'll get into that, Stacy, but we're seeing more of that overall in this theme of fiduciary transparency. Do you just want to comment on sort of the changing marketplace you see from a couple years ago to now that employers should be thinking about?
Yeah. From an employer perspective, it's become more prevalent to start using RFPs for your service providers. You want to evaluate your broker and consultant compensation to ensure that it's reasonable and accurate based on the disclosures that they've made to you at the beginning of the contract period. These voluntary benefit plans, if they're subject to ERISA, which many of them are, the employer is going to be a fiduciary, and they have a duty to monitor those service providers, the brokers and the carriers. And, those duties can't really be fully delegated away.
Yep. And when we talk about fiduciary responsibility under ERISA and prudent oversight, we're really not just talking about voluntary benefits. We're talking about healthcare benefits overall. I think you and our team over the years have been involved in many compliance audits, especially new clients coming on, sort of reviewing documents from that standpoint. So what are your words of wisdom to employers today as to the changing marketplace as they think about, I think somebody sort of explained to me that employers know or understand fiduciary responsibility on the retirement plan side. It's kind of like now that's come over to the other side of the house with everything else. Is that your view, or what are you advising clients to think about?
Yeah, I think applying the same rigor that you apply to your retirement plan maybe makes sense to do for your group health plans now. There's just more fiduciary risk now. With PBM contracts, we may see a move more toward pass-through models where employers are paying, the actual cost of the drug plus a flat administrative fee rather than spread pricing. I think we'll talk about some of the legislation that's coming up. It's really going to change and reshape how some of these contracts look.
You sort of touched on that, and at the same time these lawsuits are emerging, we're seeing a lot of new legislation around pharmacy transparency, PBM practices. And so what are some of the recent developments or the important developments that you think people need to know about as it relates to the PBM? I know you sort of touched on that, but let's sort of dive into some of that.
Yeah, sure. And here's where it starts to get a little bit dense. So yeah,
I'll reel you back if we get too far in the weeds.
Good. So we're in the beginning of an era of major pharmacy benefit manager reform, PBM reform. There is a new set of regulations that was released in January regarding PBM fee disclosure. And then shortly thereafter, there was the Consolidated Appropriations Act of 2026, which contains major PBM reforms that will go into effect for plan years beginning on or after September 1st of 2028. So 1/1/29 for calendar year plans. This will result in much more disclosure from PBMs. Employers will have enhanced audit rights. They'll be able to more easily audit their PBMs and service providers. They'll be able to choose their auditor. The PBMs won't have as much ability to limit them. We'll just see employers having more kind of control and understanding their benefit plans, I think.
Yeah, and I think it's important for people to know listening in, this really applies primarily or a lot towards self-funded employers that are contracting with a pharmacy benefit manager, or PBM. But a lot of clients that are with fully insured carriers, you're seeing a lot more changes occurring with United, Cigna, where they're saying they're not going to take rebates and they're going to do different things that, hopefully will benefit the employees of a fully insured carrier. So it's kind of hitting on both sides, but I think those that are self-funded need to kind of be more, let's say, in the weeds, as you like to say on that. Is that your view?
Absolutely. I mean, with fully insured plans, you're really concerned with one number, right? With premiums. With self-funded plans, you have the fees paid to the claims administrator, to the stop loss carrier, to the PBM. You have point solutions. You might have a telehealth vendor. You might have musculoskeletal. You might have a dialysis carve out. You could have 10, 15 different contracts for your self-insured plan. All these different vendors. You might have a subrogation vendor. So just so much more to be aware of how it operates, how your contracts work. Can you get out of them when you need to? And there's just so many more angles when you're self-funded.
Yeah. And for those that want to learn more about that, we had a great episode with Jennifer Pertlich, a clinical pharmacist on the topic. And then tomorrow we'll be recording a session with Kevin Gregory from Alaire Pharmacy. I think there's a push out there for those that are self-funded where they feel like they need to look at 3 traditional PBMs and then 3 pass-throughs, so that if they ever get called to the carpet by employees or pulled up in some kind of DOL lawsuit, they can say that they were a fiduciary and they reviewed the marketplace. Hey, Stacy, when you think about what you do and your role, talk about what comes your way as it relates to the PBM. Like, why would somebody call you up if they're reviewing PBMs or, do you sometimes review contracts? So a little plug for your services, but the value of an ERISA attorney. I think too many people don't have a good relationship with a good ERISA attorney and have their contracts reviewed.
Yeah, so we do a lot of work on service provider agreements for self-funded plans, whether there's the claim administrator, PBM, stop loss, or the other point solutions. We review for ERISA issues, it depends on the depth of the review, but make sure that that the contract's going to perform as advertised. We look for things like the limitations of liability, indemnification provisions, term and termination, just to kind of make sure that we can terminate it if we need to based on our discretion under ERISA. But, we do tend to recommend having experts review your contracts as needed. We review PBM contracts for ERISA compliance, for employee benefits issues. There are probably, provisions in PBM contracts where, there can be comp hidden where that I'll never find it. And you need, another PBM expert to come in that really knows these contracts and can look at it from that perspective. So I do think employers, use experts as needed. One of the reasons why these employers are being sued with regard to voluntary plans, last year was with regard to prescription drug plans. So it's like Richard said, it's not just the voluntary plans, but one of the reasons they're being sued is that they're allegedly failing to monitor their service providers. They're not conducting competitive RFPs. They're not benchmarking their broker compensation. They're allegedly not monitoring the loss ratios of these plans on the VB side. And with ERISA, you don't need a crystal ball. You don't need to choose the lowest cost provider, but you do need a rational basis for choosing your provider in a process for getting there.
Yeah. And Stacy, I know you've worked with our team for 20 years now, right? And I think the important thing is you get a lot of those situations where we have a conversation with you, and especially on a new client, and you say, send me the documents, right? And then we come back to the client, and the client's like, I didn't know that. I didn't read that. Nobody told me that, right? So I just feel like, it's important that everybody think about in this new era we're in with transparency and fiduciary, they have a role to play like they've played on the retirement plan side.
Yeah, and even just for their own protection, you have a groups that are level funding now. It's a type of self-funding. They can be much smaller than your typical larger, sophisticated self-insured plan, and they feel like the contract operates like it's fully insured, but you still have those contractual stop-loss provisions, and claims have to be incurred and paid within certain dates, and there could be real significant exposure out there. I think it's always good to have legal review these contracts just to make sure if there's any traps for the unwary, any timing nuances you weren't aware of. There's a lot of tricks out there.
Yep. And Stacy, the other thing that I think is important for people to hear is because we have CFOs listening to this, business owners, not just HR people, but we talk to a lot of HR people. Our friend, colleague Gail and I had lunch with an old client a little bit ago, and they're like, oh, we're happy with Express Scripts, and I really don't want to go out and do a PBM review, and things seem to be running well, right? And they might not have the team or the work, but in today's world, you need a different mindset, which is that probably every few years we need to be looking under the hood, reviewing everything. Luckily, we have a team that does that for our clients, but if somebody isn't doing that or has an HR team that hasn't done that, I think your advice to the CFO and the CEO is like, that's a fiduciary risk situation.
It is, I think. There's probably some safety if you have no complaints, the costs are relatively stable, but you can't just choose your vendor based on the brand name anymore. You really should have documented RFP processes. You should do benchmarking when appropriate. Perhaps consider whether forming a benefits committee is warranted. There's just so many more moving parts when you're self-insured than when you're fully insured.
Yeah. So healthcare benefits have historically been viewed as an HR function, but the cost and risk involved are enormous. Do you think we're entering a new era when healthcare benefits are becoming more of an enterprise risk issue that CFOs and boards need to pay attention to?
Yeah, I do. When you consider the medical trend increases, just the cost of offering a group health plan continues to go up. There's a greater prevalence of high cost conditions like cancer and diabetes, heart disease. I know some of the increased cost I've heard is due to the increased use of GLP-1s for weight loss. There's increased utilization of services. Folks are getting older. And so, these are all potential stop loss issues. They can all lead to long-term cost implications for the plan. So employers are definitely keeping a closer eye on those liabilities.
Yep. And one thing I was thinking about that we didn't cover is that on behalf of clients, you review a lot of benefit consultant agreements or services agreements. And so for those listening in, a lot of the things that we're talking about, certain consultants and brokers, they do that naturally. They review the marketplace, they review pricing. And so in a sense, a lot of employers are already paying for that service. They're just not leveraging that. So, right, I mean, in a sense, you see the compensation that brokers and consultants are getting on some of these agreements, and it's kind of like that's subsection 4B in the contract, so you shouldn't have to pay extra for that. You really should review your consultant agreement. You want to comment on that or give your perspective to somebody listening in?
Sure. I mean, sometimes there are, duplicative charges that we've seen in certain services agreements where it appears in one section and it also appears in another section as part of the PBM. There's so much to track, when you're looking at these agreements. Sometimes the cost is based on PEPM, per employee per month, or per member per month, or per member per year. There are charges that are based on percentages of savings or percentages of recovery. I mean, anytime you see a percentage in your contract, red flags should be appearing, alarms should be going off. You want to, is there a cap involved? Is a percentage really appropriate here? You want to monitor payments that are made from third parties, like rebates and service fees, and then also payments that your vendors are making to third parties, like your subcontractors. All of this takes time to monitor.
Yep. So we're at the end of our time, but I wanted to ask you one question that wasn't on our agenda as I think about our time with you and your expertise. When you think about 2026, and we're talking about these voluntary benefit lawsuits and PBM transparency, is there anything else any words of wisdom that you have for anybody listening in that they should be thinking about or that you think's coming down the pike? I remember it used to be that you and Peter would be like, we're about to, as if we were in D.C., like we're on the steps of the Capitol and here's the update or here's what you should be thinking about. Anything as I put you on the spot on that?
Yeah, well, I've always found it interesting that the Trump administration, both terms, has been a huge proponent of transparency as it relates to hospital pricing and health plan pricing. So we are definitely seeing a shift toward greater transparency, stronger fiduciary oversight, just more sophisticated management of healthcare spending. And so, like you said, using that same discipline and rigor that you apply to your retirement plan, now applying to your health plan, I think is a great idea.
Yeah, and I think what we're seeing is a lot more prospective clients doing RFPs where they say we've had a great relationship for 20 years or 10 years, and we just need to review as part of the process, but also it's educational. The other thing we're seeing a lot is as we see more senior HR people retiring, we've talked to a lot of senior people that said, I'm kicking this down the street for the next team. And so you have somebody now having to review their TPA relationship they've had for 20 years, and it's amazing what they're finding. So I think the wise wisdom is to be reviewing all your contract services agreements and feel like you have the right professional to do that. And if you haven't done that in a long time with what's going on in the marketplace, now's the time to really think about that. And then one last thing, people hear about DOL audits and they think, do those things really happen? What are the chances of having a DOL audit? We had a great conversation with Prabal, who you know, about enterprise risk. What would be your parting words of wisdom regarding the DOL and do audits really happen or not as you think about some of these things?
Yeah, they're definitely still out there. I have a relatively small firm, but we're involved in a couple of active DOL audits at any given time. They take, not months and months, they take, a year or two to complete. They can be very invasive. There's lots of interviews, lots of requests for documentation that they think you should have, that you may not, depending on how far back they go. they're not auditing 2026 or 2025. When you get a letter, it's generally like we're auditing 2021, 22, 23. There'll be some point in time a few years ago. Maybe it's due to a complaint. Maybe they've identified one of your service providers as problematic and they got a client list and now they're just going through it. So they are definitely out there. From an employer perspective, just engage in good record keeping is one of the reasons why you don't want to self-administer benefits, because the vendors usually have very good record keeping protocols, like your COBRA vendor. They're going to keep copies of envelopes and things like that. So
right. Well, we really appreciate your time today. For those that want to get in touch with Stacy, his contact information will be in the notes or the podcast landing page. And we'll have Stacy come back, because I think, Stacy, you would agree that some of these items are going to be continual interesting developments as the year goes on. And then when we add in the current administration to some of these things.
Thanks, Richard.
Wishing you another 20 years of working with you.
Thank you.
Take care. Have a great day.
Same. All right. Talk soon.